Welcome back to the deep dive. Today, we are wading into some truly murky waters, both literally and legally.
Uh-huh.
We're looking at one of the most, I think, intellectually frustrating and morally challenging areas of tort law. It's this legal distinction between hurting someone and, well, simply standing by while they get hurt.
It sounds dramatic, and frankly, it is. We are covering towards the second module 5 today.
Mm-hmm.
The focus is specifically on the concept of duty, the problem of nonfeasance, and the duty to rescue.
The central tension here is just so stark. I mean, I think most people get that the law says, I can't walk up and punch you. That's active harm.
Right. Misfeasance.
But the question we're wrestling with today is, does the law require me to throw a life preserver to someone drowning right in front of me?
A fascinating clash between, our moral intuition and what the legal obligation actually is. So our roadmap for this deep dive is pretty rigorous. We have to start by defining duty itself and distinguishing between misfeasance, that's the act of misconduct, and nonfeasance, which is just passive inaction.
Which leads us right to that harsh and honestly a pretty cold no duty to rescue rule.
Exactly. But because the law really hates a vacuum, and judges often struggle with clear injustice, we're going to spend the bulk of our time dissecting the critical exceptions, the places where the law does force you to act. We'll look at creating the peril, special relationships, undertaking to act, and interference.
And to wrap it all up, we'll synthesize everything into a diagnostic checklist that you can use in an exam context. So let's start at the very beginning. In the context of negligence, when we say a defendant owes a duty, what are we actually saying, and who gets to make that call?
So duty is the first and really the most significant gatekeeper in a negligence claim. Fundamentally, it establishes that there is a legally recognized relationship between the defendant and the plaintiff that obligates the defendant to act or refrain from acting in a certain way.
And this isn't something the jury decides, right? They don't just get to say, yeah, I feel like he owed him a duty.
Precisely. Duty is a question of law for the judge. It's a policy-based determination. The judge is essentially the gatekeeper, deciding whether the plaintiff's claim is even something the court system is willing to entertain. If the judge says, no duty, the case is over, before the jury even sits down.
So when a judge is making this policy call, they're not just, flipping a coin. There's a framework they use.
Right. They often use a balancing test, a lot of which comes from the California case Rowland v. Christian. It's a complex calculus. They're looking at things like the foreseeability of harm, the certainty of the injury, and how close the connection is between the defendant's conduct and that injury.
But they also look at broader societal factors too, don't they?
They do. They weigh the moral blame attached to the defendant, the policy of preventing future harm, the burden on the defendant to avoid that harm, and, crucially, the availability of insurance. The judge weighs all these competing interests to decide if a duty should exist on a societal level.
Okay, so that's the broad definition. Now let's get into the meat of this module, which is the difference between acting and doing nothing. You mentioned misfeasance versus nonfeasance. This seems to be the pivot point for everything else we're going to discuss.
This is the critical distinction. Misfeasance is active misconduct that works a positive injury on someone. You drove too fast, you fired a gun, you pushed someone. In those cases, a duty of reasonable care is almost always presumed because your actions created the risk.
Versus nonfeasance.
Right. Nonfeasance is passive inaction. You failed to take positive steps to benefit someone or protect them from a harm that you didn't create. And the general black-letter rule is there is no liability for nonfeasance.
Let's test this immediately, because on paper it sounds simple, but in practice it can be pretty shocking. We have the case of Yania v. Biggin. This is a Pennsylvania case from 1959. So let's analyze Yania v. Biggin. First, what are the legally dispositive facts?
Okay, so you have the defendant, Biggin, and the decedent, Yania. Both are competent adults. They're standing near a large trench filled with water on Biggin's property. And this isn't a swimming pool. It's a dangerous cut in the earth. Biggin, verbally cajoled, taunted, and urged Yania to jump into the water.
Like, I dare you, jump in, that kind of thing.
Exactly. And Yania, apparently succumbing to the peer pressure, jumped. He struggled in the water and eventually drowned. Biggin just stood by and did absolutely nothing to rescue him.
So we have a man taunting another man to his death and then just watching it happen. And what was the core legal issue here?
The issue is, does a defendant who verbally urges a competent adult to engage in a dangerous act owe a duty to rescue that person when they then fall into peril?
What rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
The court applied the rule of nonfeasance. The rule states that liability is imposed for misfeasance, that's active misconduct causing injury, but generally not for nonfeasance passive inaction, unless a specific exception applies. So the elements to test here are, first, was the defendant's conduct misfeasance, and second, if it was nonfeasance, was there a duty to rescue based on some other factor?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, misfeasance?
Well, the court had to decide if cajoling or taunting actually counted as active misconduct. The analysis really focused heavily on the fact that Yanya was a competent adult. The court reasoned that mere words, urging someone, do not constitute the physical creation of a risk in the same way that pushing someone would.
So because Yanya jumped on his own?
Exactly. Because he jumped voluntarily, Biggin's words were not the legal cause of the peril. Therefore, the court found no misfeasance. It was Yanya's act, not Biggin's.
Understood. Now what about the second element, nonfeasance and the duty to rescue?
Well, since the taunting wasn't misfeasance, the court looked at Biggin's failure to throw a rope or jump in as pure nonfeasance. The sub-rule here is that the law imposes no duty to rescue a stranger. The court analyzed whether there was any special relationship or other status that would trigger a duty. They found none, so they held that Biggin had no legal obligation to act.
And after analyzing all the elements, what was the court's final conclusion?
The holding was that the defendant, Biggin, is not liable. His conduct was nonfeasance, and the law imposes no duty to rescue a stranger, even if the defendant's taunts were part of the reason the victim was in that position.
That's a tough pill to swallow. It feels incredibly cold.
It is cold, but it really reinforces the court's reluctance to legislate morality.
To really drive this point home, and to make sure our listeners understand just how absolute this rule can be, let's look at a visceral hypothetical that comes up in almost every torts class, the Olympic swimmer.
Yes, this is the classic illustration of the rule's harshness.
So imagine an Olympic gold medalist swimmer. She's sunbathing on a deserted beach. She looks up, sees a small child drowning in the surf just a few yards away. She knows she could swim out, save the child, and be back on her towel with absolutely zero risk to herself.
Zero risk.
But instead, she decides she doesn't want to get wet. She turns over and continues tanning. The child drowns. Under the common law, what happens?
Under the common law rule of nonfeasance, the outcome is no liability. The Olympic swimmer walks away completely free.
That seems insane to the average person. I mean, it seems monstrous. Why does the law allow that?
It really boils down to a fundamental distinction between law and morals. The courts have said again and again that the law is not the proper forum to enforce benevolence. And there are a few key justifications. First, there's the concept of American individualism, this idea that we don't want the state forcing people to serve others involuntarily.
The mind your own business defense.
In a way, yes. But the second justification is practical. The difficulty of drawing the line. I mean, if the law says you have to save a drowning child, what's next? Do you have to give money to a starving beggar? Do you have to donate a kidney to a dying relative?
It's a slippery slope argument.
Precisely. To avoid those slippery slopes, the courts chose to draw a bright line at nonfeasance. If you didn't cause the problem, you don't have to fix it.
So the baseline is, unless you fit into an exception, you can just watch. That brings us to the most important part of this discussion, the exceptions. Because while the general rule is no duty, the exceptions are where the liability actually lives. Let's start with the first big one, creating the peril.
Right. This is the idea that if you are the reason the plaintiff is in danger, you forfeit the right to just walk away.
What's the general rule there?
The rule, which you can find in Restatement Section 322, is that if an actor's conduct, even if it's innocent and fault-free, creates a risk of harm to another, a duty arises to exercise reasonable care to prevent any further harm.
Even if innocent. That's a key phrase. To see this in action, we have the case of South v. National Railroad Passenger Corps.
This is a case with facts that really test the limits of human decency, maybe even more than Yanya.
Okay, let's analyze South v. National Railroad. First, what are the legally dispositive facts?
So, a train operated by the defendant collided with the plaintiff's pickup truck. Now, importantly, for this specific issue, the collision itself may not have been the railroad's fault. It could have been an unavoidable accident.
Okay.
But the crash happened. After the crash, the plaintiff was trapped and exposed to freezing temperatures. The railroad employee on the scene was wearing a jacket. He refused to cover the injured, freezing plaintiff with his jacket, and his reasoning, which is in the record, was that he didn't want to get blood on it.
He valued his jacket over the victim's suffering. And what was the core legal issue in that case?
The issue is, Does a defendant whose conduct contributes to an accident owe a duty to assist the injured party to prevent further harm, even if the initial accident wasn't caused by the defendant's negligence?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the creating the peril exception. The rule is that an actor whose conduct has caused a physical harmful incident has a duty to use reasonable care to prevent further harm. The elements are, first, causation of the incident, and that doesn't mean negligent causation, just factual involvement. Second, a subsequent failure to exercise reasonable care in the rescue.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply the first element, causation of incident?
Well, the court looked at the crash itself. The defendant's train was physically involved in the collision. The court decided that regardless of whether the engineer was negligent in driving the train, the defendant's conduct helped create the perilous situation. That factual connection, just the physics of the crash, was enough to trigger the duty.
Understood. Now what about the second element, reasonable care?
The court analyzed the employee's behavior after the crash had already happened. The plaintiff was freezing to death. The means to help a jacket was right there. The employee refused to use it to protect his property. The court found this failure to act was objectively unreasonable given the gravity of the plaintiff's peril versus the trivial cost of, a dirty jacket.
And after analyzing all the elements, what was the court's final conclusion?
The holding was liable. The duty to rescue attached because the defendant's conduct contributed to the situation, and they breached that duty by failing to provide reasonable aid.
Okay, so the lesson there is if you break it, you buy it, or at least you have to help fix it. Let's move to the second major exception, special relationships.
This is probably the most common exception you'll see. If you have a relationship of dependence or mutual dependence, the law imposes a duty. Historically, this list was very narrow. Common carrier passenger, innkeeper guest, captain seaman, that sort of thing.
But that list is growing. And we have to talk about Farwell v. Keaton. This case involves two friends, Segrist and Farwell, and it represents a huge expansion of the rule.
It really does. It represents a massive shift in how courts define what even counts as a relationship.
So let's analyze Farwell v. Keaton. First, what are the legally dispositive facts?
Segrist and Farwell were out on what the court called a social venture, basically drinking and trying to meet women. They got into a fight with a group of other men. Farwell was severely beaten. Segrist escaped, but then he came back, found Farwell, and drove him around for a while. He applied some ice, but then he eventually just left Farwell unconscious in the back of his car in a driveway. Farwell never woke up. He died of his injuries.
This feels different than Yanya. Here, they were friends. So what was the core legal issue?
The issue is, do social companions who are engaged in a common undertaking owe a legal duty of rescue to one another when one of them falls into peril?
What rule of law did the court apply? Please state the full black-letter rule and bring it down into its testable elements.
The court applied a very broad version of this special relationship exception. The rule they came up with is that a special relationship exists where parties are engaged in a common social venture with an implicit understanding of mutual aid. So the elements are, first, the existence of a social venture or companionship, and second, knowledge of the peril.
Thank you. Now for the court's elemental analysis. Let's walk through it. How did the court apply that first element, social venture?
This is the really controversial part. The court looked at the fact that they were out drinking together, pursuing a common social goal. The court actually analogized this to teammates on a mountain climbing expedition.
Wow.
Yeah. They found that this companionship created a sufficient legal relationship to impose a duty, arguing that friends on an outing like that implicitly rely on each other for safety.
Understood. Now what about the second element, knowledge of peril?
Segrist absolutely knew Farwell had been in a bad fight. He knew he was unconscious. He knew he wasn't waking up. By leaving him in the car without seeking any medical attention, Segrist breached the duty of care that was generated by their relationship. He knew of the peril, and he failed to act reasonably.
And after analyzing all the elements, what was the court's final conclusion?
The holding was liable. The court effectively expanded special relationships to include friends on a social outing, creating a duty where, frankly, none existed before.
That's a fascinating analogy, equating trying to pick up women at a bar with scaling Mount Everest. It basically creates a legal wingman duty.
It absolutely does.
That brings us to our next category. Sometimes you don't have a duty, but you decide to help anyway, and then you mess it up. This is the undertaking to act exception.
Exactly. The law says you don't have to be a good Samaritan, but if you choose to be one, you have to do it responsibly.
Yeah.
You can't start a rescue and then just abandon it halfway through if it leaves the person worse off.
And what's the general rule here?
The traditional view was you were only liable if you left the victim in a worse position. But the modern view is a bit broader. Once you start to rescue, you have to act reasonably.
We see this in cases like Parvey v. City of Kingston.
Right. In that case, the police picked up a drunk man. Now, generally, police act under discretionary authority. But here, they actually took him into custody. They didn't have to pick him up. But once they put him in the car, they undertook a duty.
And then they just dropped him off near a highway.
Correct. And he wandered into traffic and got hit. The act of taking him into custody created the duty to keep him safe. They couldn't just dump him in a dangerous spot.
So don't start what you can't finish properly. Now, closely related to this is the idea of interference. What if I want to help, but someone else stops me? This brings us to Soldano v. Daniels.
This is a fascinating case because it imposes liability on a third party who effectively blocks a rescue. It's one of the few times a business owner was held liable for something happening completely off their premises.
Let's analyze Soldano v. Daniels. First, what are the legally dispositive facts?
A shooting occurred at a bar. A good Samaritan ran across the street to the defendant's establishment, a totally different business, to use the phone to call the police. The bartender refused to let the patron use the phone, even though the phone was in a public area and using it would have cost nothing.
The bartender literally blocked the call. And what
Yeah.
was the core legal issue?
The issue is, does a business owner owe a duty to permit a good Samaritan to use a telephone to aid a victim of a crime that's occurring off premises?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court relied on Restatement Section 327, which is about interference with rescue. The rule is that one acts negligently if they prevent or disable a third person from giving aid. The elements are, first, knowledge that a third party is attempting to render aid, and second, negligent interference with that aid.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply that first element, knowledge?
Well, the facts showed the Good Samaritan explicitly told the bartender, "There has been a shooting, I need to call the police." The bartender had actual knowledge of the emergency and the attempt to aid. He couldn't claim ignorance.
Understood. Now what about the second element, interference?
The refusal to hand over the phone was the interference. The court noted that while the bartender had no duty to run across the street and perform CPR himself, he had no duty to rescue personally. He had a duty not to impede someone else who was trying to help. Blocking access to the phone was a negligent interference with that rescue effort.
And after analyzing all the elements, what was the court's final conclusion?
The holding was liable. The court saw this as a logical extension of the rule against interference. They famously noted that the law has to break the chains of outmoded no-duty concepts when they clash with basic human decency in a public place.
We've covered a lot of ground here. We have the harsh general rule and then this minefield of exceptions. For our listeners preparing for exams or just trying to keep this straight, how do we synthesize this into a workable framework?
You need a step-by-step diagnostic checklist. When you see a negligence fact pattern, do not jump straight to reasonable care. You will miss the issue.
Okay, walk us through the steps.
Step 1 is classification. Ask yourself, is the defendant's conduct misfeasance, active risk creation, or nonfeasance, a failure to act? If it's misfeasance, you're in standard negligence territory. Apply the general duty of reasonable care and move on.
But if it is nonfeasance?
That's step 2, the nonfeasance default. If you determine it's nonfeasance, they just stood there. You have to start with the presumption of no D-duty. Write that down first. Generally, there is no duty to rescue.
And then?
Then step 3 is the exception hunt. You have to systematically check for the specific exceptions that trigger a duty. First, creation of peril. Did the defendant even innocently cause the danger? If yes, they have the duty to rescue. Second, special relationship. Is there a recognized dependency? Look for parent-child, carrier-passenger, or that Farwell social venture. If yes, duty to rescue.
What about the others?
Third, undertaking. Did the defendant start to help? If yes, they now have a duty to be reasonable and not worsen the position. And fourth, interference. Did the defendant stop someone else from helping? If yes, liability under Soldano.
And I assume there's a final check for any written laws.
Correct. Step 4 is statutory contractual. Just check if there's a specific statute or a contract that mandates aid.
That's incredibly helpful. Before we sign off, I have one final provocative thought. We saw in Soldano and Farwell that courts are really stretching these definitions. Social venture for drinking buddies, interference for refusing a phone call. Are we slowly moving toward a general legal duty to be a good Samaritan?
It's the million-dollar question. We're definitely seeing a trend where courts are uncomfortable with the coldness of the common law. They're finding ways to impose liability. But there's still a massive tension between individual autonomy, leave me alone, and social responsibility. We're all in this together.
Yeah.
The line is moving, but for now it hasn't quite reached the point where you have to save the stranger. But you certainly can't stop someone else from doing it.
Well, there you have it. In the world of torts, sometimes the most dangerous thing you can do is nothing at all, especially if you're the one who lit the match. Thank you for that rigorous dissection.
My pleasure. Remember, in torts, keep your eyes open, and if you start to help, don't stop halfway.
See you next time on The Deep Dive.